As Abraham Lincoln is believed to have said, you can't trust everything you read on the internet. Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today, we're responding to a post my wife found on Instagram. Like many of the social media apps, Instagram doesn't fact-check things that are not political. So lots of information that is misinformation gets put out there on things like Instagram and Facebook. And this is one of those. We're talking about this post, and here's what the post says. If you make one payment on your car note, then hide your car for 6 months. The bank will charge it off on their taxes and can no longer repossess it as collateral, essentially giving you a free car. Sometimes the idiocy that manifests itself on social media is a bit daunting. Like if there were 90 hours in a day, I couldn't debunk all of it. But this one is especially bad because it is liable to get somebody arrested. Let's start with the first sentence. If you make one payment on your car note, well, why would you only make one? Well, unless it is to demonstrate that you really weren't trying to steal the car that you're really trying to steal. Now, you might very well be able to claim later on that this showed your intent to honor the secured credit transaction that you entered into willingly with the bank or the credit company, but that's going to have little weight with a judge or a jury because instead of doing the honorable thing and turning the car back in, you attempted to hide it for 6 months or more. If your goal is to avoid jail, the easiest and best way to do that is to make payments or return the collateral. Next, our genius information provider here suggests that you can hide your car for 6 months and then the bank will charge it off of their taxes. Well, maybe, but most likely not. First of all, there will be the phone calls. They'll come every day. Mr. Jones, you haven't paid your car payment. Why not? Even if you duck the phone calls, at some point, they're going to turn it over for repossession and collection. Now, repossession, they hire a recovery service or a tow service, and that person goes and camps out outside your home. You leave the garage door open. Likely, they're going to get in there, grab your car, and take it. If you don't leave the garage door open, if you keep it closed, what good is having a free car if you can't use your free car? And frankly, unless you take a lot of steps to conceal where you have it, even if you put that car on the street for a few hours, there's a good chance a motivated repo guy is going to find it and take it. And if you keep it in a garage away from your residence, like a storage place, one of those 24-hour storage places, then your chances are better of getting away with hiding it, but you best keep the charges paid there, otherwise they're going to take the car. But here's the thing, once a repo order has been entered by a bank, it usually isn't recalled. They'll be looking for that car for a lot longer than 6 months, and they can take it even if the bank has charged it off. That's because the bank can always amend its tax return to include it as income in the next tax year. Now, this rule may be different in some states, but for the most part, they can still take that vehicle. But let's go a step further. Let's suppose that you actually succeed in keeping it hidden for 10 months. And during that 10 months time, nobody sues you. Well, now you feel like you have a free car. You get in your car, you drive everywhere you go, but then one day you look at the license plate and you realize, guess what? I have to take this to the DMV and get my plate renewed. So when you go to the DMV to renew your plate, here's what happens. They say, this isn't your car anymore. The lien has been foreclosed on this vehicle. They've issued a new title, a replacement title, and the vehicle isn't yours. You can't drive it away from here. And just like that, your free car is no longer a free car anymore. But that is unlikely to happen because it's far more likely what will happen is when the bank can't find your car to repo it and the collection agency gets hung up on 96 times, they're going to sue you for the bad debt. Now, maybe they'll have trouble finding you. Maybe they won't be able to serve you for a few months. But eventually, they're going to get you. If you save the money you could have paid the bank, maybe you can afford a $200 an hour lawyer, but most likely not. Meaning you either negotiate with the bank collection agency or you oppose them in court, and if you do the latter, you'll be served with discovery. And in that discovery will be a demand to disclose the location of the vehicle. Once you disclose the location of the vehicle, the court's going to issue a writ of replevin, which goes to the sheriff and it tells him to seize the car. And it's going to be held until the lawsuit is finalized, and then it's going to go back to the bank. But in the meantime, while you're fighting, you're making a record of your irresponsibility, thereby destroying your credit rating and sending your car insurance rates skyward. Now, I suppose you could refuse to cooperate in discovery. Lots of people do that. You just refuse to answer the questions posed, you don't respond to the filings, and now the judge has to force you to respond. So what do? They issue an order to show cause. And the order to show cause requires you to come into court and explain to the judge why you won't answer this discovery. And if you say, I'm not going to tell him where the car is, the judge is going to say to you, well, I think you are, or you're going to spend, the rest of your time here in the clink, because that's where we're going to throw you. We're going to throw you in jail for contempt of court. And that's what will happen. And you'll be there until you cooperate and then reveal the location of the car. But wait, that's not all you get. What you've done here is called fraud. And every state has a statute on fraud. Some of them are more general, some of them are more specific. This is the Missouri statute, and it is more specific. It talks about defrauding secured creditors. A person commits the offense of defrauding secured creditors if he or she destroys, removes, conceals, as in like hides the location of a vehicle that is subject to a secured credit transaction, encumbers, transfers, or otherwise deals with the property subject to a security interest with the purpose to defraud the holder of the security interest. The offense of defrauding a secured creditor is a Class A misdemeanor unless the amount remaining to be paid on the secured debt, including interest, is $750 or more, in which case defrauding the secured creditors is a Class E felony. Well, a Class A misdemeanor, you only have to go to prison for a year, but a Class E felony, you're going to have to go for 4. Other states have similar statutes. What this means is that the bank calls your detective bureau in the local police department and reports your car as stolen by deception. And the detective pulls the case file from the court, and if you are unwise enough to have not cooperated and are in there because you're in for contempt of court, even if the judge lets you out, the detective is going to tell you you're going to go right back in for felony theft. So what happens? Well, you've made a perfect record of your intent to deprive the bank of their collateral and their money on the secured transaction, and as a result of that, what's going to happen is you're probably going to be convicted. Even if you get a public defender, the public defender is going to push you to take a deal rather than take this case to trial, because juries tend to be made up of people who are responsible and pay their debts, and they don't like people who don't pay their debts because they all recognize that people who don't pay their debts increase their costs. So by the time you get out of state prison after a 4-year sentence for fraud, you have no credit rating, you have no car, you have no job, you have no job prospects because you have a criminal record, you have the inability to vote in some states, and the inability to ever own a firearm again because you've been convicted of a felony. And your free car, well, that was repoed and sold to a little old lady who only drives it on Sunday. Now, we tell people this all the time. If it sounds too good to be true, it is. Sometimes people say it probably is. I have never found an exception to the rule, ever. I'm 68 years old. Take it from me. It is. It's not probably. It is. I have talked about Charles Ponzi on this channel before. He was a master con man and a master manipulator. He is famous for saying he never stole from an honest man. Well, how could he say that? Because he was offering 50% return on investment at a time when most everyone else was getting 2% to 4%. And people kept plugging their returns in his con game back into his con game and seeing their wealth exceed their wildest imagination. And then one day, just like that, they were flat broke. Bernie Madoff made off with a bunch of wealthy people's money, doing exactly the same thing. He got lots of different people, including Hollywood types, who were taken to the cleaners. The court gave him pretty much the maximum sentence in that situation. Here's the bottom line. This idea of hiding the car for 6 months sounds too good to be true, and I can assure you that it is. Now, does that mean that maybe one or two people have gotten by with this kind of stuff? Maybe. Maybe they have. But do you really want to bet your good fortunes the rest of your life on such a deal, knowing that it's going to destroy your credit rating? I would certainly hope not. Hey folks, please excuse the interruption, but let me ask you if you would, if you haven't already, please subscribe. And if you would, hit that like button and maybe even leave a comment. That tells YouTube that this is a valuable video and they'll refer it to more people. It helps me out a lot and I appreciate it. Thank you. Many years ago, I knew a guy who bought a Ford Mustang. It was a bright red. He showed it to me. It had T-tops. It was fun to drive. One day he got a letter in the mail from the bank with a copy of his note marked paid and the title to the car. It was a mistake. The note hadn't been paid. Someone else's note had been paid, and the clerk at the bank did the wrong thing and sent the wrong note. So he knew it hadn't been paid because he hadn't paid it. But he immediately took the title to the nearest dealer, which happened to be a Chevy dealer, and traded for another vehicle. In fact, what he traded for was a Chevrolet Citation. Now, how you could think a Chevrolet Citation was in some way comparable to a Ford Mustang with T-tops, I don't know, but that's what he did. Then he left the state of Missouri and went to Florida, got a job, and lived his life merrily. But as you might imagine, since he had a job, he could be found, and he was found. And he was served with a lawsuit, and the bank sued him for the full amount that was due on the note. He tried to respond to the lawsuit, tried to handle it pro se, and he realized he was going to get shellacked, so he negotiated with the bank, and he found, much to his amazement, that the bank was willing to take about 25% less than what he owed. He worked overtime for about a month and a half, and he spent every waking hour doing this overtime, and he sent all of that money to the bank. And then at the end of the year, he had to send a whole lot more money to Uncle Sam. He was now in a higher tax bracket because of what he had done. Then he wondered why his car insurance almost doubled when he had no tickets or accidents. He tried to rent a condo in Florida and was told his credit was no good. They couldn't rent to him because he had a very bad credit rating. All because he thought he could beat the bank at their own game, and he couldn't. I would later tell him exactly how stupid I thought he'd been, and he swore he would never do that again. But my friend did not learn a lesson. He took a job in Georgia. He was an EMT, and he got on-call work, so he had to have a pager. And this was back in the years before cell phones, and as a result, he just got himself a pager that got him he paid $25 a month for it. And when it went off, he would call the ambulance company and they'd say, hey, you need to come back. We've got a long distance transfer we need you to do. So he would go and do the transfer, and that made having the pager work very well for him. But then a funny thing happened, and he got hired full time by the ambulance company. And so he didn't need his pager anymore. He worked a set shift. So he went back to the pager company, handed them the pager, and said, hey, I'm done with this. And the company said, whoa, hold on a minute there, Tex. You signed a lease for a year. You have to pay us for a year whether you use this thing or not. And sure enough, that's what the contract had said, and he knew that. They got the pager back. Why in the world would they want to continue to bill him? But they did continue to bill him. And when he didn't pay, they engaged some debt collectors to hound him, and they called him at home, they called him at work, they called his boss at work and told him that he was a deadbeat, and that violated the Fair Debt Collection Practices Act. So somebody told him about this statute, this federal statute, and he filed a case pro se in state court saying that the Fair Debt Collection Practices Act had been violated. And he had the debt collector sued. And as a result, the debt collector, in order to avoid a much larger penalty, essentially paid off the debt to the pager company. And now he was just over the moon happy because he had found a new way to scam people. He would later tell people that you really didn't have to pay anyone. You just wait for the debt collectors and smash them with an old lawsuit. I told him, look, this is a dangerous way to live. You're creating a record of being a deadbeat and irresponsible person. This is going to make your life hard. And indeed, it did. So here's the bottom line. You try to tell people things like this, and they don't listen. I want to try and help people who might fall victim to this kind of, what would I call it? This kind of idiocy. That's what I'll call it. It's idiocy. You can't take a loan out on a car, hide the car, and then get away with it. It doesn't work that way. And the guy who put that post on Instagram ought to know that. But some folks never learn. You should learn from their mistakes and don't let their mistakes become your mistakes. Never loan these people money, especially if they're family, because family tends to think of it as a gift and not a loan. Never loan them money. If you do, you will be perpetually sorry that you did. So that's what I have for you today. Hopefully you found this interesting, educational, informative. If you have any questions, leave them in the comments down below or send them to me by email at the email address up above. Like, share, subscribe, all that stuff we ask you to do. A little commercial that I bury in here in the middle of this thing. Take care. Have a terrific day. And catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.